Good afternoon, GPAR. How's it going? So happy to see so many people here with us this afternoon for our workshop here with Janis Benstock. But before we get into today, I want to look ahead to next week. We have a number of different sessions coming your way, and that starts Monday, YPN. And this is a committee that Janis heads up. We're going to have restorative yoga. It's part of their wellness effort that we've been doing this past year. So it's the next session as it relates to that. We've sent it out in the emails. Check the email. There's a QR code to register. It's a limited amount of spaces. So if you're looking to stretch out after you've been around all your friends and family over the holiday festivities and weekend, please consider joining us Monday at 10 a.m. Looking ahead to Thursday, Agreement of Sale workshop. This is one of our most popular workshops that we do. Trent Pettis will be heading that up. It's a 3-hour session. It's for both the newbie, the grizzled veteran. It's very interactive. Trent will answer any question that you have, and it's really cool because you guys help to drive the conversation from the various experiences that you've had on the practitioner side. So we invite you to join us for that. And then at the end of next week, looking all the way ahead to Friday, December 6th, we will have a legislative update from the Pennsylvania Association of Realtors. We're going to have their head legislative person, Sherry Martin, join us from Harrisburg. She's going to tell you about the different pieces of legislation that have been passed or enacted that impact real estate, give you a little bit of an update on where things have kind of shaken out as it relates to the election. So lots of good stuff there. We hope you'll join us for those sessions next week. And with that, I hand it off to Janis Benstock. Hey, Janis.
Hey, Matt. Hey, everybody. Buenos dias. I just came back from Mexico, so I'm speaking what little Spanish I know. I'm glad everyone's here. I want to, first of all, say that you absolutely do not need to have your cameras on, but I don't care what you look like. I would much rather talk to faces. So if you're feeling inclined and comfortable, I would love for you to turn on your camera. It just makes it more of an interactive thing where I could see people and we could communicate. Thank you. I appreciate it. Okay. So the first thing I want to do is I want to ask everybody why you're here, because my plan for this is to go over the buyer agency contract on a screen share, the exclusive and the non-exclusive, and to walk through it. But we're all already in the business. And so before I just start blathering, I would like to check in with you and know why you're here. Do you have a specific question, a specific concern? And if you could just take a minute and everybody could throw that in the chat. And it's not a requirement, but that way I can customize this to help you guys where you really need it. That would be great if you just take a minute to throw that in the chat. That would be super cool. Oh, and I'll tell you why I'm here. We have a theme here. We have a theme. Okay. Okay. Newly licensed. All right. You're my people. Does anyone have a specific question or concern, especially relating to the NAR settlement agreement? Because I'm going to talk about some of that, but if anyone has a special question or concern about that, throw it in there now, and I'll make sure that we spend some time drilling down. Otherwise, based on everything, it looks like we're just looking for refreshers and keeping it fresh and general professional development. So off we go. I lied. Before off we go, I'm throwing one thing in the chat. And this is a Facebook group for YPN. And I'm going to give it a plug because I'm the chair of YPN and I really believe in this. So this committee, YPN stands officially for Young Professionals Network, and it has nothing to do with your birth year. It has to do with being young to the business. However, we have, with Matt, close your ears. We have sort of unofficially renamed it Your Professional Network because it's really for everybody. So the young to the business are going to get a lot out of it, but the people that have been in the business for a while are going to be like the mentors and the ones that are going to help them and bring them into, tap them on the shoulder and bring them into the fold. Because as you know, by being here, being a member and being involved in GPAR probably changed your career. I know that it changed mine. So we have a Facebook group now, and we're doing that restorative yoga on December 2nd that Matt mentioned. It's only $10. The teacher is a good friend of mine. She's an Iyengar teacher. If you've never done Iyengar yoga, it is really good for your body. And it's not the flow kind of yoga that takes a lot of energy. It's restorative, and it's just working on different postures. So it's good to balance your body and your mind and connect with other agents. And Spire Abstract is giving us free, fresh, cold, I think it's cold pressed juices or something after the class. So that's that with that. All right, without any further ado, I'm going to screen share and pull up the buyer agency contract, and we're just going to have some fun with this. Here we go. So as you guys know, or hopefully know, and this is something weird, I got a new computer and I still haven't figured it all out yet. So first thing is, can everybody see my screen? Somebody jump in and say yes, because I cannot also see the Zoom screen at the same time. So if you need me, you're going to have to unmute and holler. It's really weird, but I haven't fixed my computer yet. So can you guys see it? Can somebody unmute and say we see it?
You're good. You're good.
Perfect. Okay. And if you need me again, just unmute, and every once in a while, I'll just check back on the Zoom. Okay. So we have two buyer agency contracts. One of them is the exclusive, which is this one, and the other one is the non-exclusive. So there are times to use both of them. We're going to go over both of these contracts. We're going to point out the places where they are different and always have a discussion about when business-wise is the best to use which one. Now, before we start on this, we have to remember that using a buyer agency contract has been a law under the Real Estate Commission since 1998, maybe 1999, but I'm close. It's either 98 or 99. So as far as the NAR settlement agreement, nothing has changed as far as legality is with using a buyer agency contract. We have always been required, since I was 3 years in the business, we've been required to use a buyer agency contract when we are representing a buyer. So for those of you, you don't have to throw yourself under the bus, but I know some of you have probably not been using it until August, when it seemed refreshed and like it was new, but we've always had to use it. And now it's even more imperative, because in addition to being the law, we're also using this as a way to protect our commission, because there is no guaranteed commission from the seller at this point, which we are all aware of. So this exclusive buyer agency contract, which we're going to start out with, and just a quick refresher on zip forms in general, on PAR form, not on zip forms, but on PAR forms, to get you refreshed. If you see in the upper left-hand corner, it says Pennsylvania Association of Realtors. That's because PAR is the one that creates these forms. There is a standard forms committee. There are attorneys at PAR, and they draft all of these contracts, the agreement of sale, all the addenda, everything that you're going to find in zip forms with the little PAR logo at the top, to be in compliance with not only regular contract law, but also to be in compliance with the RELRA, the Real Estate Licensing and Registration Act, because the RELRA requires certain clauses to be in our contracts. And we don't have to worry about them as practitioners, because PAR does the heavy lifting for us. But be aware, if you're a broker or your broker uses forms that are not created by PAR, that they must have these certain clauses in them. And I'll point them out when they come in, not a full list, but just so you sort of know what I'm talking about. So this says this form is recommended and approved for, but not restricted to use by members of PAR. So people who are non-members can purchase these contracts, but we get them included as a benefit of our membership. This is the name of the form, and then here is an abbreviation. It's usually 3 or 4 letters. And so when you get familiar with them and you use them over and over again, you could just pop that in the search bar. In zip forms, it's an easier way to find it, but you can also search a whole bunch of different ways, but that's all this is. Okay. Now we're going to start with the exclusive buyer agency contract. A buyer agent owes duties of loyalty and confidentiality to a buyer and must act in their best interests. So if you go back and remember, when we create agency between us and a client, either a buyer, seller, landlord, or tenant, we're creating the fiduciary responsibility, the fiduciary relationship. And that fiduciary relationship covers care, confidentiality right here, loyalty, accounting, and disclosure. And I think I forgot one. Care, confidentiality, obedience, accounting, loyalty, and disclosure. So it's saying it right here, and it's sort of starting to explain and lay down the groundwork for what this relationship is. And we must act in their best interest. That's the loyalty right there. That's the basis of the fiduciary relationship. If a consumer chooses to purchase property without hiring a buyer agent, that consumer will not have a real estate licensee looking out for their interest in the transaction. Now, as a practitioner, if anyone has comments or questions, just jump in, because again, I can't see you. So as a practitioner, we know that we're supposed to go over all of these contracts line by line with people. And to the grave, I'm going to take that statement with me, because that's what I'm telling you to do. However, in real life, IRL, I know that we don't always have the time nor the attention span of our clients or customers to go over these things line by line. That being said, the best path that I've ever seen to getting this information to people without losing their interest and without spending 17 hours on every document is to read the documents yourselves and understand them, which is really great because you're here and you're doing that with the contract. As you read and understand these contracts, these statements and these facts, such as that we represent somebody with a fiduciary relationship responsibility, they're going to come up in conversation as you're sitting down talking to a buyer about whether or not they want to work with you or whether or not you want to work with them. So the more you understand it, the easier it's going to be for you to explain these contracts without having to sit down and go over every single line. And that's one of the things that we talk about with our value proposition, especially now in the time where we're not guaranteed that we're going to be paid a commission by the seller. And we have to now really explain to our buyer, you're paying me unless the seller does. We have to explain to them and really understand and embody what our value is. And part of our value is that we are representing them. And we all know that, but we have to know the language so that we can explain it to them. And this right here does a pretty good job of it. In an exclusive buyer agency contract, you agree, we're talking to the buyer, that you will work with only one buyer agent for a certain time period. This is key to the exclusive buyer agency contract. There is a specific term and it is exclusive for a certain time period, and that you could owe a broker's fee to this broker if you purchase a property during the contract time period. Contacting another buyer agent and using their services during the term of this contract could mean that you might owe fees to more than one broker. Questions? We good on that? All right. Do not sign this contract until you have read the entire document and discussed any questions with the agent. If you have further questions about this contract, you can also discuss them with the agent's broker or manager. And if you have legal questions, you're advised to consult a Pennsylvania real estate attorney. Always encourage them to hire an attorney if they feel that it's necessary. And as much as sometimes attorneys can make deals a little more difficult for us, it is always in our client's best interest if they choose to have an attorney. And it takes some of the liability off of us, so we can look at it that way. Any questions about the preamble? And this is really important because you have to be able to explain this to people when you're getting them to sign a contract. Is anyone nervous? I'm going to switch back to Zoom for a second. You can raise your hand. Is anyone nervous about presenting the buyer agency contract to people? Everyone? Anyone? No? Yes? Okay. It can be nerve-wracking. And one of the things to remember is this whole situation up here is starting to think, and if you have to take notes to sort of build out what your value proposition is and what you're charging people for, these are some of them, is the loyalty, the confidentiality, and also the expertise. One thing to shy away from, because this is not what our value proposition is for the most part, is data. Data is everywhere unless you have a pocket listing or you're going to go find a property, knock on doors or call people or whatever to find a property. Our value is not in data anymore. Our value is in representing our clients and maybe negotiating, maybe knowing contracts, or a combination of all of those things. The top section here is obviously the same as in all of our sections, in all of our contracts. The broker information goes on the left and your information goes on the right. And this is just a reminder that every single contract you sign with a client is really between the broker and the client, not between you and the client. It is between the broker and the client, and you are an agent for the broker. So the parties to this contract are the broker and the buyer. And we're going to put the buyer's name and information in here. Obviously, not everyone has a fax, but fill out as much information as you possibly can, including their mailing address. If there's a blank there, try and fill it out. It's not legally binding if you don't fill in their address, but best practice is to fill it in if it's there. What was I going to just say? Oh, identification. This is something that I keep saying I'm going to put into my practice and I never have, but I'm going to tell you to do it anyway. Start carding people. I still don't understand, and I've been in the business a very long time, why we don't card people before we get them to sign contracts. Whenever you sign a contract anywhere else, you always have to show ID. So it is a good practice to have people show ID before they sign a listing contract and a buyer agency contract. The one thing that I'm going to caution you is that if you do it for one person, do it for every single person. There is no picking and choosing who you're going to card and who you're not going to card. So either do it for everyone or do it for no one, because otherwise we run into possibilities of fair housing issues. The other thing is, we all know the line numbers are here. So we can refer to those line numbers in addenda. If we need to change something or reference, we reference a line number. Okay, buyer understands that this exclusive buyer agency contract is between broker and buyer, not between you and the buyer, broker and buyer. And does buyer have a written agreement such as a buyer agency contract with another broker? Yes or no? If they have another exclusive buyer agency contract, then they check yes. There better be an explanation. And the explanation could be something like, yeah, but it expires next week. And then your contract won't start until that one is expired. Otherwise, it should be no. I can't really think of any other reasons why it could be yes. But if you come up with one and it makes sense, it makes sense. But they can't be under two simultaneously. Paragraph 1, starting and ending dates of buyer agency contract, also called the term. Now, this I just want to point out right here, this date 8/24. Whenever you see a date in parentheses after a paragraph, that means it's the last time the paragraph was touched, meaning it was either changed, it was updated, it was moved around. And so obviously this one was touched because of the NAR settlement agreement. We got new forms that were released in August. And if you look down at the very bottom of the form where my cursor is, it says revised 8/24, released 8/24. This way you know that you have the most up-to-date form, because sometimes you might see an old form, and this way you know you always have the most up-to-date one. So no law or association of realtors has set or recommended the term of this contract. This is something that the RELRA requires. Remember, I told you there's certain paragraphs in there that a contract has to have. It has to say that nobody has set the term, that the broker and the licensee, the broker or licensee and buyer have discussed and agreed upon the length or term of this contract. Now, does anyone know what the limit is for the length of a listing contract? I'm going to switch back for a second. There's a law under the RELRA that says how long a listing contract can be. Anyone know? Just holler. We're an intimate group. 1 year. Exactly. I saw Renee. Does anyone know how long the RELRA says a buyer agency contract can be? It's kind of a trick question, because the answer is it doesn't say. There is no limit. However, I've asked that question, and when I say Hank, I name drop Hank like he's my BFF, Hank Lerner, who's head counsel of PAR, and I ask him lots of questions to the point when he's just like, go away, right? But one of the questions I asked him was, what about a buyer agency contract? And he said, since there's no law, best practice is to also limit it to 1 year, because that's what the listing contract is limited to. So I'm passing that along from Hank to me to you. Okay. B, this contract applies to any property. This is the special sauce that makes it exclusive right here. This contract applies to any property that buyer chooses to purchase during the term of this contract. Buyer will not enter into a buyer agency contract with another broker that begins before the ending date of this contract, which is what this section is for, right? So they're pledging to you that during the term of this contract, anything that they buy, you are their agent and you're going to be owed a commission. That's why they can't have two, because they can't make that pledge to two people. The starting date, this contract starts when signed by buyer and broker unless otherwise stated here. So this doesn't need to be filled in unless you're post-dating the contract. For example, today is what, November 20, what's today? I'm making it up. The 27th. I don't know what it is. I'm on Do Not Disturb. I can't look at my watch. The 26th. Today's the 26th. If I'm signing a contract today, but it doesn't start until December 1st because the buyer is under contract with someone else until November 30th, that's when I would put December 1st in here, right? Otherwise, I'm just going to leave it blank because it's going to start today. If it's going to start in 2 weeks because they're on vacation, whatever, you post date it. Otherwise, you just leave that blank because that's what it says. The ending date, this contract ends at 11:59 on blank or before if buyer and broker agree. We can always, by mutual assent, decide to terminate a contract. The ending date of this contract may not be extended without the written consent of the buyer. Again, there is no limit, but best practice is keep it to 1 year or less. If buyer is negotiating or has entered into an agreement of sale, this contract ends upon settlement. One thing to remember is that even though this is an exclusive buyer agency contract and it says that it's going to cover any property that they purchase within the time period, it's only for one property. So if they purchase a property, this contract terminates and then they want to buy another one, they're a free agent. They can either sign up with you again or they can go work with someone else. So it only covers one. Any questions? Questions? Okay. So now we're going to go into the broker's fee again. Last touched 824 because of the settlement agreement. The part that they added was law. No law or association of realtors has set or recommended a broker's fee. Broker and buyer have negotiated the fee broker will receive for exercising professional knowledge and skills in locating and assisting buyer in the acquisition of real property, which is available and suitable for buyer. That pretty much sums up what your promise is in this contract. Their promise is to pay you. Your promise is to help them with your professional knowledge and skills to locate and assist the acquisition of real property, which is available and suitable for them. And that all starts with the buyer interview, which is not the scope of this today, but if you have any questions about that, how to talk to your buyer, throw them in the chat and we'll get to them if there's time. Okay, now let's talk about our commission. First thing is I'm looking you in the eye here. I should have started with this. We don't talk numbers in this group. We don't talk numbers with other agents. We don't talk numbers in Facebook groups. We don't talk numbers at dinner. We don't talk numbers, period, because talking numbers can be considered a violation of the Antitrust Act and it can be considered collusion and price fixing. Even though we know it really might not be, that's what the law says, and it's a federal law, right? So we have to be extremely careful. And it can be a little bit challenging because we've seen things in the news, like the New York Times had a headline that said the 6% commission is dead. And we're like, what do you mean? And I had a seller say that to me the other day. And they're like, well, now I heard there's no more 6% commission. I was like, whoa, there never was. And we have to go and we have to explain the whole thing. So when we do these contracts in these refresher courses, we're going to talk donuts and we're just going to say random crazy numbers. And you can think whatever number in your head that you choose to charge, because in the marketplace, you, meaning you and your brokerage, can set what your fees are as business. But what we cannot do as an industry is set fees between companies. So your company can say, I'm going to charge 17 donuts, and that's your policy. And when you meet with a buyer, you say, I charge. But what you cannot say is the fee is, indicating in any way, shape, or form, or implying in any way, shape, or form that that is the going rate, because there is no such thing as a going rate. And I'm going to take it one step further. The word discount, I strongly advise you all to strike that from your language if you use that, specifically talking about discount brokers, because if someone's a discount broker, what are they discounting from? That would be the norm or the standard, right? We've all heard people say, oh, they're a discount broker because they're only charging 14 donuts. How could someone be discounting if there's no standard, right? There are 100,000 ways to charge commission, and we're going to talk about a few of them now. So let's get into this paragraph. Broker's fee paid by buyer to broker. I cannot stress this enough. The conversation with our buyer must be, this is what I charge, not maybe the seller will pay me. This is what I charge. You have to look them in the eye and say to them with 100% confidence and conviction, this is what I charge. Then you can say to them, if the seller pays me, which may or may not happen, you won't have to. But if the seller doesn't pay me, then we can try and negotiate with them and try and figure out a way to get them to pay. But if they don't, you're paying me. And you have to be able to say to them in your own words, but in a way where they know it's not like, this is what I claim, right? You have to be able to explain it to them. So here's how it's written in the contract. In a purchase transaction with a seller represented by a broker, this broker or another broker, which means whether it's dual agent or whether it's co-op, we are charging X amount of donuts. Or we're charging a flat fee, whichever is greater, and another fee, an additional fee, Z, okay? So here's the thing. You have always been able to charge. And when I say been able to, it's obviously up to your broker, but as a broker, they're able to charge a percentage. They're able to charge a flat fee. They're also able to charge extra fees, and they're able to charge any way that the parties agree to, by the hour, by retainer, by per property. It's just, they're not choices in our contract. But if your broker, your business decides that you want to come up with a new way to be paid, you are free to do that, and you are encouraged to do that because there is no standard. It's just a matter of getting it written up legally and properly in a contract, which an attorney would need to do. But you are not limited to charging this way just because that's what's in our forms. That's what's in our forms because that so far has been the most common way. So that's what our members have been using, but that may change at any time. So be aware that you have the choices. But the way this is currently worded, if you use this, you're charging a percentage fee or a flat fee, whichever is greater. And if you charge another fee on top of that. You also can fill out the same information for a seller who is not represented. And the reason that you might have a difference is maybe you think if the seller is not represented, I have to do more work because the seller doesn't know what they're doing. And so I might charge my buyer more. Or you might look at it and say, well, if the seller is not represented, then there's chances of them offering me a commission or less, and I don't want my buyer to be on the hook for it, so I'm going to charge my buyer less. These are some of the ways and examples that you might use to make a different commission structure for a property that's represented versus a property that's not. Any questions so far? Okay. Number 2, advance fee or retainer. You can charge, and I'm totally making up numbers just so that we have, let's say you charge $10,000. And that can be standard because there's no sales price. We can say $2,000 of that has to be earned and due, non-refundable at the signing of this contract. This advance fee will be credited against any other fees stated in this paragraph unless otherwise stated here. You have all the flexibility in the world to charge people up front if they want you to drive them all over town, if they're undecided, if they're like, well, we want to shop around, but then we might end up renting, and you decide business-wise that you're not willing to take that risk on for free, you can charge them up front. It's negotiation, and we could talk about that much more. That has to do with mindset and value proposition, and it's a business decision, but you absolutely do have that option, and that can either come off of this, what they agree to pay you, or it can be an addition. You could say it's an addition to, and that's totally fine. Okay. Other, maybe this is where you say, we're doing an hourly, see attached addendum, or we're doing a retainer, or we're doing a per showing, whatever it is that you want, you can put that in there. Number 4, broker will not retain any amount greater than the broker's fee agreed to in paragraph 2B, regardless of the source. Super important. This is a direct result of the NAR settlement agreement. It was one of the big changes. For me, the hardest pill to swallow out of the whole thing. Hopefully it's easy for you. This means that if your contract says $10,000 and the listing agent is offering $10,001, you are limited to $10,000. End of story, full stop. There's no way around it. There's no loophole. I've heard everyone say, well, can we just rip up that contract and write a new one? That is not the spirit of the settlement agreement. Can you and will you maybe not get caught? I'm not going to be the one that comes and bails you out of jail, right? Don't do it. If you sign a contract with a buyer that says this is what you're charging, that is what you're charging. If you then see that a seller is offering a huge bonus or a higher commission, you're SOL. So either that number is going to go back to the seller or back to the buyer. This is something that's going to have to shake out in the marketplace that there's no rule for. So that's something that you're going to have to do on a case-by-case basis to figure that out. Does anyone have any questions about that? Any issues have come up since August with that? I know there was some concern. I know a couple agents that work for builders, and the builders like to offer big bonuses, and that's a real challenge because, how do you know about that ahead of time? Anyone have any issues with that? If not, we'll move on. Okay. And then our fee right here, if the buyer leases a property instead of buying, what is your fee? And this is really good to put in there because you might have those people that are like, oh, I might decide to rent instead. This is a way to cover your butt. One thing I want to just point out at the bottom of every page right here. This is your brokerage information. I'm the broker, and I always forget I think this is the broker's name. I'm not sure if maybe someone can tell me when you log on as an agent, is that your name or your broker's name? I don't really know because this is my zip forms and I'm the broker, but this is your contact information. And so my strong suggestion to you is that when somebody says to you, oh, I'm just going to do it by myself, like one of your friends, can I have a blank contract? The answer is no, because this brokerage information is on there. And I've heard stories where people have stolen contracts and used them. And the agent wasn't involved, but the agent got pulled into the lawsuit. So I would be really careful. It's obviously a choice of your office, your broker, but I don't let people use these because my name is on them. So if I'm not involved in the transaction and my E&O doesn't cover it, I'm not letting people use it. D, even though broker's fee or portion of it may be paid by a seller or a listing broker, broker will continue to represent the interests of the buyer. It is broker's policy to accept compensation offered by a listing broker called cooperating compensation. If a listing broker offers cooperating compensation that is less than the broker's fee above, buyer may authorize broker to negotiate an increase by using a form such as the CBC. 2, sellers sometimes offer to make financial concessions toward paying buyers' closing costs at settlement, which could include some or all of the broker's fee agreed to in paragraph 2B. If it is not paid as cooperating compensation by the listing broker, buyer can negotiate these seller concessions by including them in an agreement of sale. Y'all cool on that? That's new. That's all new. Why is it new? Because here's what it's saying. And this is how the conversation has to go to the buyer. This is what I charge. The seller may offer commission. If they offer the same amount of commission that I'm charging you, you're cool. It's baked into the sales price. If they don't, we have a few options. We can ask them to pay part of your commission as a seller concession, or you can pay it to me yourself. That is the conversation. You can say it nicer and sweeter, but that's the conversation. The conversation is not now, nor has it ever been, oh, the seller pays my commission, it's free to work with me. that's part of what got us into trouble in the first place, is people were saying that. Does anyone have any questions on how to have that conversation or what that means to their buyer or about the commission? We'll just move on. All right. And we can also talk about the CBC and the agreement of sale if we need to. Okay. That was easy. Okay. E, buyer understands and agrees that if broker receives less than the broker's fee agreed to in paragraph 2B through any combo of cooperating compensation and seller concessions, buyer will be responsible for paying the remainder of broker's fee due to broker at or before settlement. Easy. F, the balance of broker's fee is earned, and a lot of people don't realize this is in the contract. So if you're reading this for the first time, you're going to like it. The balance of broker's fee is earned if buyer enters into an agreement of sale during the term of this contract, whether brought about by broker, broker's licensees, or by any other person, including buyer. If buyer defaults on the terms of the agreement of sale, broker's fee will be paid by buyer to broker at that time. Buyers advise that contacting a listing broker or seller directly may compromise broker's ability to earn cooperating compensation from a listing broker and could result in buyer's obligation to pay a fee. If your buyer defaults, they still owe you a commission. That does not mean that you have to go after them for it. That is your choice. It is a business decision, but the contract allows for it. It's very similar to, well, it's the same thing in a listing contract. If you procure a ready, willing, and able buyer, you've earned your commission even if you haven't received it yet. And if the seller defaults, where the seller chooses to not accept that offer, you can go after your commission. So it's the same concept, because remember that our promise, I talked about that in the beginning of the contract, our basic promise was that we were going to use our reasonable skill and professional knowledge to help them locate suitable property and help them negotiate through. And their promise is they're going to pay us. If we do our promise, but they don't hold up to their promise, they still owe us a commission. We earn when we procure. We receive usually at settlement. Does anybody have any questions about the difference? Nope? Okay. All right. If buyer enters into an agreement of sale for a property after the ending date of this contract, buyer will pay broker's fee if the agreement of sale is a result of broker's actions during the term of this contract, or the property was seen during the term of this contract, and buyer is not under an exclusive buyer agency contract with another broker at the time buyer enters into an agreement of sale. That is the same as the broker protection clause in the listing contract, the one that says within X amount of days, if someone of the expiration of this listing contract, somebody buys the property and it was somebody that I introduced, I'm going to get paid. It's the same thing. So we're protected under this as well. Dual agency, this paragraph is important, and this is also one that's required by the RELRA. Buyer agrees that broker and broker's licensees stated above may also represent the seller of the property buyer might buy. A broker is a dual agent when the broker represents the buyer and the seller in the same transaction. A licensee is a dual agent when they represent the buyer and seller in the same transaction. All of brokers' licensees are also dual agents unless there are separate designated agents for a buyer and a seller. If the same licensee is designated for buyer and seller, the licensee is a dual agent. Buyer understands that broker is a dual agent when buyer is viewing properties listed by broker. Any questions on that? My suggestion to you is explain dual agency to your buyers, because not everybody wants to work with a dual agent. Some people just don't, and it's not a bad idea, because dual agency is ripe for litigation. It's a huge conflict of interest, and you have to be really careful when doing it. It's legal, but it must be disclosed. So if you're working with a buyer, what I always say to them is, because I don't have tons of listings, so I always say to them, I do not represent the seller unless I do, and then I'll tell you about it before we go look at the house. If you have tons of listings, you could say it the opposite way. I'm going to show you my own listings. If I don't represent them, I'll tell you one way or the other, or you can just tell them every time I walk up, I do not represent the seller or I do represent the seller, but they need to know. They need to know. Questions about dual agency? Big one. Okay. Designated agency. So let's talk about this paragraph, because the way agency is set up, you as a licensee, as an agent for the broker, when you sign a contract with somebody in the broker's name, you're really signing it for the broker, which means every single agent in your office also represents this buyer. And that kind of makes no sense, because they're not working with the buyer, they don't know the buyer, and they shouldn't be held liable in case something happens with the transaction. So most offices choose designated agent. It's your office choice, it's your broker's choice, but typically we do designated agent, which means if I saw Anne-Marie here, Anne-Marie signs a buyer agency contract. If she does not elect designated agency, that means every single agent in her office is also representing that buyer. And that's kind of cuckoo. So our contracts are written this way. Designated agency, we're in paragraph 4. Designated agency is applicable. By default now, the contract is saying, forget about every single agent representing. It's Anne-Marie's agent. It's Anne-Marie's buyer. That's why her name is in here as licensee. So we're going to do designated agent. The broker is designating Anne-Marie to be the agent for this buyer. But if we check below here, for whatever reason, the broker wants every single agent in the office to represent, then we check that box, and then designated agency is not applicable. Any questions about that? So most contracts that I see, this is going to leave it unchecked. Any questions? All right. Broker services to others. Broker may not take action that is inconsistent with buyer's interest. That's loyalty. That's putting their needs above and beyond even those of our own. That's the fiduciary. However, broker may provide services to a seller for which broker may accept a fee. Such services may include, but are not limited to, listing their property, representing them as a seller agent, doing deed or document prep, offering certifications required for closing, financial services, title transfer and preparation services, ordering insurance, construction, repair, or inspection services. Providing such services is not in itself a breach of broker's fiduciary duty to buyer. B, broker may show the same properties to other buyers and may represent those buyers in attempts to purchase the same property that buyer wishes to purchase. Broker does not breach a duty to buyer by showing a property buyer is interested in to other prospective buyers. That's kind of creepy. I've been there. It is not a fun place to be, but it's totally legal to do that. And here's the $64,000 question. If you are representing two buyers and you write up offers for both of those buyers on the same property, do you have to tell them?
Yes. No?
No, because think about it. And this kind of, that's why it's a tricky question. Because on the one hand, it feels like, and that's why I want to talk about it, because on the one hand, it feels like, oh, I should tell them, I should disclose. But if you think about it, what do you have with each of those buyers? You have a fiduciary, care, confidentiality, obedience, accounting, loyalty, and disclosure. So imagine now that you had two buyers and you put offers in on two different properties. Would you think of telling each other? Absolutely not. Absolutely not, right? You wouldn't say to Joe, oh, by the way, I'm working with Mary and she put an offer in on this property over here. What does Joe care? It has nothing to do with him. So just because it's on the same property doesn't mean that you can violate that confidentiality, because that's what it would be. And it feels like you should disclose, because we're always told disclose, 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 but not in this case. See why? Does it make sense now? Okay. Continuing on. C, it is a conflict of interest when broker or licensee has a financial or personal interest in the property and or cannot put buyer's interest before any other. If broker or broker's licensees has a conflict of interest, buyer will notify broker in a timely manner. You'll know it when you feel it. If there's a conflict of interest, you should know it like right in your guts, in your kishkas, and then you have to disclose or recuse yourself. 6, and this is in all of our contracts, entire contract. This contract is the entire contract between broker and buyer. Any verbal or written agreements that were made before are not a part of this contract. All changes to this contract must be in writing and signed by broker and buyer. So when we change, and again, this goes to your office policy, but when we change contracts, there's 2 ways to do it. We can do an addendum, which is to add. We grab an addendum from Zip Forms and we fill out the information and we get it signed. That's clean. And in a lot of ways, we like that better because then we don't have a whole marked up contract. Or we can do an amendment. Amend means change, where we can go into the contract and we can cross something off and everybody initials and dates it. There are pros and cons to both, but it's really important to understand in relation to this paragraph what the pros and cons are. Paragraph 6 says this is the entire contract. Nothing that we signed, nothing that we said before matters. And if we sign something after, it matters. But here's the problem with addenda. Addenda can get lost. They can float, right? They're not attached to the contract. It's not in the old days, even when Staples broke or came undone, but at least in the old days we had paper and we put them all in a file. And even though you could technically lose a paper, for the most part you open the file and you saw everything. But addendum now, we send them off separately in email and DocuSign to people, and then if we forget to put it in the file, we forget that there's an addendum out there somewhere, it can be like really confusing and we forget we changed the price. Whereas if we amend the contract by crossing it off and everybody initially, yes, it gets sloppy, that's a downside, but then it's at least all in one document. So these are things to consider in your practice when you're going through deciding how you're going to change your contracts when things change, because they always do. Questions? Yell if you do, because I don't see screen. Okay. Transfer of contract, number 7. Buyer agrees that broker may transfer this contract to another broker when the broker stops doing business, when the broker forms a new real estate business, or the broker joins his business with another. Broker will notify buyer immediately in writing if it's transferred to another broker. Buyer will follow all requirements of this contract with the new broker, which is fun to think about. If you are a broker, you can sell your business, you can sell your contracts. I'm not saying that you should, but you can because they're transferable. Confidentiality, unless permitted by buyer or required by law, broker will not knowingly reveal or use any confidential information of buyer. Buyer understands that seller or seller's representatives might not treat the existence, terms, or conditions of any offer as confidential unless there is a confidentiality agreement between buyer and seller. This paragraph will survive the termination or expiration of this contract. As part of the fiduciary that we owe to our client as a buyer agency, confidentiality lasts forever. After the transaction is over, after the contract expires and there was no transaction, we owe confidentiality. But the seller and the seller's agents do not owe confidentiality to the buyer, meaning they can say whatever they want to say unless there's an agreement stated. So it's okay to use confidentiality agreements or non-disclosure agreements, and sometimes they are applicable. Otherwise, it is fair game. Number 9, expertise of real estate agents. Pennsylvania real estate agents are required to be licensed by the Commonwealth of Pennsylvania and are obligated to disclose adverse factors about a property that are reasonably apparent to someone with expertise in the marketing of real property, that'd be you. If buyer wants information regarding specific conditions or components of a property which are outside the broker or licensee's area of expertise, buyer is encouraged to seek the advice of an appropriate professional. If buyer wants financial, legal, or other advice, buyer is encouraged to seek the services of an accountant, lawyer, or other appropriate professional. Never be the source, always be the source of the source. When it comes to stuff that is outside of your lane, such as zoning, law, environmental, home inspection, never be the source, be the source of the source. That's what this is talking about. What it's also talking about is that you kind of have to know what you're doing. And my favorite example is my niece was buying a property in Baltimore, and I'm not licensed in Maryland, so I could not help her with the transaction, but I went down there for the home inspection, and I got there early because she's in her 20s and she's always late. I love her to death. She shows up and she's all excited. I was there early, and the minute I walked up to the house, I noticed it was like, it wasn't plumb, the whole house. And I looked around with the home inspector and I'm like, this house is falling down. She went through a whole entire home inspection for $650 and ended up crying a puddle of tears and terminating. And then she bought another house with a different agent. That agent should have seen what I saw when he walked up to the front door and told her, and then she would have decided. And if she went through with the purchase anyway, she wouldn't have fired him, but she ended up firing him because he should have known the basics. How do I know the basics? Because I followed every single home inspector around for the last 28 years, and I learned something every single time. So you do have to have a level of knowledge. You're not a home inspector, but if the house is like this, you should know it and tell your client about it. You should have an expected level of knowledge. 10, deposit money. Broker will keep or give to the listing broker, who will keep all deposit monies that broker receives in an escrow account as required by the real estate licensing laws and regulations until the sale is completed or an agreement of sale is terminated or the terms of a prior written agreement between buyer and seller have been met. Buyer and seller may name a non-licensee as the escrow holder, like a title company or an attorney, in which case the escrow holder will be bound by the terms of the escrow agreement, not by the RELRA. The RELRA is what governs us. Buyer agrees that the person keeping the deposit monies may wait to deposit any uncashed check that is provided as deposit money until the seller has accepted the offer. Okay? Regardless of the apparent entitlement to deposit monies, Pennsylvania law does not allow a broker holding deposit monies to determine who is entitled to the deposit monies when settlement does not occur. So we have this conversation with our buyer, and I know this one gets people into trouble often, too often. And this goes when you're writing up the agreement of sale, but the time to start talking about it is when you're doing the buyer agency contract. The trouble arises when we write up an offer for the buyer and we elect the mortgage contingency clause, and we say to the buyer, and I'm going to look you in the eye right now because I know we've all said it, every single one of us at one point in time said to the buyer, don't worry, if your mortgage doesn't go through, you're going to get your money back. Shut your mouth and don't ever say that again. If you've ever said it, don't ever say that, because what happens is listed in the agreement of sale. And here, regardless of the apparent entitlement, the buyer it's apparent that he's entitled to the money, but is the broker allowed to release the money? And the answer is no, not unless they get a signed release by both parties or a court order, or they have written permission prior to the transaction of what they should do in case of a dispute. And that's what they're saying here. That's what this whole paragraph is saying right here. So it's really important that we understand that and that we explain that to our clients. So the conversation is, if your mortgage doesn't go through, you should be entitled to it, but the seller is going to have to sign off. So if there's an issue, we would go to mediation and then mediation litigation. Okay. Civil Rights Act. Federal and state laws make it illegal for a seller, broker, or anyone to use, and these are federal and state laws, race, color, religion, religious creed, sex, disability, whether it's physical or mental, familial status, remember, as children under 18, age in Pennsylvania is 40 or older, national origin, use or handling training of support or guide animals, or the fact of a relationship or association to an individual known to have a disability as reasons for refusing to sell, show, or rent properties, loan money, or set deposit amounts, or as reasons for decisions relating to the sale or rental of property. I teach lots of classes on fair housing, so we're not going to dive too deep into it, but just be aware that if you have someone that you feel that you're going to start working with as a buyer and you feel that there might be discrimination against them for any one of those protected classes, that you speak to your broker ahead of time, because the number one goal here is to get your buyer equal access to property, and it's not to get the seller in trouble. I've seen it happen where maybe someone has a guide dog, or maybe someone has a physical handicap, and you're afraid that they're not going to let them buy the property. preempt it and talk to your broker and come up with a plan. Okay. Notice regarding convicted sex offenders. This is a big one. Pennsylvania General Assembly has passed legislation referred to as Megan's Law, providing for community notification of certain convicted sex offenders. Buyers are encouraged to contact the municipal police department or the Pennsylvania State Police for information relating to the presence of sex offenders near a particular property, or to check the information on this website. Here's the deal. You are allowed to point out this website. If you point it out to one person, you point it out to every person. What you are absolutely not allowed to do is point to the house and say, oh, you should check Megan's List to see, because, maybe there's some sex offenders that live around. Because sex offenders, first of all, have rights too, whether you like it or not, but they do. And the second thing is, we also have to be careful that we are not, if a sex offender lives here, the house next door, what can happen to the value of their property? It's external depreciation, isn't it? The value of my property could go down if I live next door to a sex offender, but does that have anything to do with me? No, it has nothing to do with me. So we have to be really careful that we don't inadvertently cause people's values to go down because we're like, oh, there's sex offenders living by. So just be careful that you just point out that website to everybody. Buyer's inspections. Unless buyer and seller agree otherwise, real estate is sold in its present condition. Don't even get me started about the words as is. I'll go off on a tangent. All real estate is sold in its present condition. It is buyer's responsibility to determine whether the condition of the property is satisfactory. Buyer is advised to carry out an inspection at buyer's expense by qualified professionals to determine the condition of the structure or its components. Areas of concern may include, but are not limited to, and I'm not going to read them all, and then I'm right here. Buyer should discuss inspections and any special needs with licensee. And you will have people from time to time that are like, I'm violently allergic to cats. So you obviously need to know, did any cats live there? Have the ducts been cleaned? Like that kind of thing. Before you even, I've had clients that were so allergic, we couldn't look at houses where cats had been in the last like 5 or 10 years. So they were really limited. So make sure that you know these things ahead of time. Buyers advise that information regarding properties considered for purchase by buyer has been provided by a seller or seller's broker. Such information may include, but is not limited to, the information in the seller's disclosure, including environmental conditions, MLS information, including information regarding restrictions, taxes, assessments, association fees, zoning, dimensions, boundaries, and marketing information. Unless otherwise noted, broker has not verified the accuracy of this information, and buyer is advised to investigate its accuracy. We know that it's in the contract to protect us. Always make sure that you say it numerous times. This is what the MLS says, not this is what the square footage is. The MLS says the square footage is this. If we want to check it, we can check it. Never say the square footage is. Always cite the source, be the source of the source. And you got to get in the annoying habit of doing that in every single thing that you say and write, so that you say it all the time. Because if there's ever a problem, if someone ever has an issue and there's mediation or there's litigation, if you can show that you say that to them and to every single client over and over again, it's going to set the precedent, and you're going to have a better chance in court that you didn't misrepresent, that you did cite the source. Does everyone understand that? Any questions? You see your faces. Any questions about that? Okay. So, recordings on the property. Any person who intentionally intercepts oral communications by electronic or other means without the consent of all parties is guilty of a felony under Pennsylvania law. Audio, they are talking about audio. They are not talking about video. If there's audio, it has to have consent of all parties. And if you don't tell someone that they're being recorded, then there's no way they can consent. So tell your buyers, we always tell our buyers They're not allowed to record audio, but assume that they are so that they don't say anything that they don't want the sellers to hear. And then we always tell our sellers, do you have any audio? We ask them, do you have audio or video? And we always suggest that they turn it off. And if they're not going to turn it off, then they have to disclose it. Buyers should not make any recordings on the property that capture the oral statements of other persons without having the full consent of all persons who are parties to the communication. It goes both ways. Buyers should be aware that a seller's property may contain smart home technologies or devices which may record or allow for remote monitoring of the seller's property, including broadcasting or recording video and audio. Buyers should be aware that any discussions, including discussions of negotiation strategies held on the property, may not be confidential. Even the look on their face and their body language is a tell. You know, you have to coach your buyers to have their poker face on. And then here's our release or indemnification. Buyer hereby releases all brokers, their licensees, employees, and any officer or partner of any one of them and any person, firm, or corporation who may be liable through them from any claims, lawsuits, and actions which may arise from any audio or video recordings occurring in or around the property considered for purchase by buyer. Okay? And then the real estate recovery fund. And this is also a requirement by the railroad that this is in our contracts. Quick refresher on the real estate recovery fund. It exists to repay any person who has received a final court ruling against a Pennsylvania real estate licensee because of fraud, misrepresentation, or deceit in a real estate transaction. The fund repays persons who have not been able to collect the judgment after trying all lawful ways to do so. For complete details about the fund, call this number. So real quick refresher, the real estate recovery fund is there. If an agent or a broker gets sued because of fraud or misrepresentation and the court awards a judgment, the consumer tries to collect on the judgment and can't. The consumer can then call the real estate recovery fund and apply for a payment. And so long as they have tried all reasonable measures to get the money from the licensee to collect on that judgment, so long as they are not the spouse or the representative of the spouse of the licensee, so long as it's within 1 year of the final judgment and including all appeals, they can collect. They're limited. They can collect up to $20,000 per occurrence. And the total against the licensee is $100,000. If it gets to that point and you're the licensee, the moment that payment is made from the recovery fund, your license is suspended until you pay that money back at 10% interest per year. That's what the recovery fund is. And we are obligated to inform people about it, which is why it has to be in our contracts. And I think it's not in bold, but it has to be in our contracts. And that's why that's in there. So that's the real estate recovery fund. And then this, if you're including any part of the contract, because remember earlier we said this contract is its contract in its entirety. So if we're attaching any addenda that need to be checked here, and then this is how you go to jail for being a lawyer without being a lawyer. Okay? Stay away from this paragraph of additional terms, and I cannot stress this enough. I cannot tell you, especially in an agreement of sale, how many times I see agents submit offers with a whole paragraph or 2 lines in there, and the reality is you are not allowed to write those. Your attorney is allowed to write those. You are not allowed to write them. Don't write them. Because you can say something that sounds in English like it is what you mean, but in legal speak, it could be something completely different. Does anybody know what the penalty is for practicing law without a license? Anyone? It's fun. Anyone? It is $2,500 fine and up to a year in jail for writing in that paragraph. Okay? There's a question. Before I finish, how would dual agency apply to married couples who are both agents? I have a listing, and if a buyer approaches me, I pass it to my husband. Well, it doesn't matter that you're married. It matters that he's another agent or she's another agent in your company, pass to husband. So if you're passing it to your husband in the office, then your husband works for the same broker. Matt, did you need me? You turned your camera on? No. Okay. So if you're both agents and you guys want to list this together, you can co-list this together. But if you have a listing and the buyer approaches me, you pass it to your husband, then your husband has to fill out a buyer agency contract with that buyer and create a relationship with them. And then you guys are designated agents. So you as the listing agent and he as the buyer's agent are designated agents, and the broker is dual agent. Does that answer your question? Yes? Okay, if not, jump back in and let me know. All right, so the last bits, and then we're just going to go into the non-exclusive and show the difference. Buyer has read and received the consumer notice. Consumer notice is a whole other thing. Please provide the consumer notice to people at the first substantive conversation about real estate. So that means somebody walks into your open house and it's packed and there's 20 groups in there and they're all running around and they're like, which way is the upstairs, right? Where are the steps? And you point to them, where's the steps? That is not substantive conversation about real estate. Therefore, you are not required to go over and have them sign the consumer notice. But when they come into the kitchen and they start asking you questions about the house and the price and the comps, now this is becoming substantive. This is time to go over the consumer notice with them, which is a whole other class. But if you have not read the consumer notice recently, or you're nervous about how to provide the consumer notice or what to say, the best practice is to read it, and then I'll drop my contact information in there. You can contact me if you have questions, or obviously your own broker, but make sure that you get that consumer notice signed well before the buyer agency contract, unless you're meeting them for the first time all at once and you're going to do it all together. Buyer has read the entire contract before signing. Buyer must sign this contract. If buyer is obtaining financing, buyer shall promptly deliver to broker a copy of all loan estimates and closing disclosures upon receipts. I never get the loan estimates, but we're supposed to get them. Buyer gives permission for broker to send information about this transaction to buyer's fax numbers and or email addresses listed. That is because if they are on the do not call list, by signing this, it gives permission for you to contact them even if they're not on the do not call list. So that's important, that why that's in there. Return of this contract and any addenda and amendments, including return by electronic transmission bearing the signatures of all parties, constitutes acceptance by the parties, which means DocuSign is fine. This contract may be executed in one or more counterparts. Counterparts means you have two buyers. You give the copy to one buyer, you give another copy to another buyer. They each sign their copy. You put them together. It's one contract. It's very rare these days because of DocuSign, but in the olden days, we would have to FedEx one to California and one to New York and put them together, and that was DocuSign. That was counterparts. Notice before signing, if buyer has legal questions, they're advised to consult a Pennsylvania real estate attorney, and the parties to the contract are the buyer or buyers and the broker accepted on behalf of you as the licensee if your broker allows. If your broker does not allow, then your broker is the one that needs to sign this. End of story, end of buyer agency contract. Any questions? No? All right, I'm going to pull up the non-exclusive buyer agency contract and just show the difference, and then we will real quick go into if anyone has questions, and then I will let you out of here. Let me just pull up that one real quick. Exclusive. Here it is. Okay. Oops. There we go. Now you can see it, non-exclusive. We good? All right, so this is all the same. Except for right here where it says in a non-exclusive buyer agency contract, and you'll see it's called NBA for non-exclusive buyer agency contract. I'm sorry. In a non-exclusive buyer agency contract, you agree that you will work with a specific buyer agent for certain properties. but that you do not have to work with them and they do not have to work with you, which is really important for every property you may be interested in. Contacting another buyer agent and using their services after you have been introduced or been shown a property under the terms of this contract could mean that you might owe fees to more than one broker. Now, here's where it differs from the exclusive buyer agency contract. Starting date and term of the non-exclusive buyer agency contract. Again, no law or association of realtors has set or recommended the term. Now it says the contract starts when signed by buyer and broker unless otherwise stated here. And C, buyer and broker agree that this contract is not time limited, but applies only to the properties listed below, if any, and any other properties introduced or shown to buyer by broker after signing this contract. So, do you fill in the blanks or do you not fill in the blanks? The best practice advice straight from PAR is either fill them all in or fill none of them in. My suggestion to you is fill them all in. So you fill in all the ones in the beginning that you're going to show, and then whenever you're going out to show them more property, putting it in writing somehow, just sending an email saying these are the properties we're going to see and attaching that in the file just so that you have a record of the ones that you showed in case there's ever some question as whether or not you introduce the property should hopefully cover you. And I say hopefully because I'm not the judge and the jury, right? So does anyone have any questions about this section? Anyone? Okay. All right, so broker's fee. The broker's fee, this part was just added to the non-exclusive in August. It was, and you see it right here. In the past, if you remember the non-exclusive buyer agency contract, it said if you contact a listing agent or if you choose to work with two buyer agents at the same time, you could end up owing me a fee, but it doesn't talk about what our fee is. And I was like, well, how can they owe you a fee if we don't talk about what the fee is? Now we talk about what the fee is. So you can charge people the same that you would charge them under an exclusive, or you could charge them different. You could charge them whatever you want so long as it's by negotiation and it's written up the same exact way. When they're represented by a broker, it's blank percent or flat fee, whichever is greater, and if there's a flat fee, and it's written the same exact way. And we'll talk about strategy in a minute. The same thing, broker will not retain any amount greater than the broker fee, regardless of the source. And here's where we go. That also shows it's different from the non-exclusive, from the exclusive buyer agency fee. The balance of broker's fee, we're on F. The balance of broker's fee is earned if buyer enters into an agreement of sale for any property introduced or shown to buyer, whether, and it doesn't matter how they bought the property, it's if it was introduced or shown to them by you and they purchased that property, they owe you a commission. Those are the differences between the exclusive and non-exclusive. Every other thing is exactly the same. So, do we have any questions about the differences between the two, or strategies when to use one versus the other, or how to have that conversation with anyone? Anyone? Okay. Did anyone have any questions about anything? Did anyone learn anything? Did anyone not learn anything? Need feedback? Okay. Matt, did you learn anything? Matt learned. Yes. All right, good. All right, fabulous. Fabulous. So I'm going to leave it there and let you get back to your day. I'm going to drop my contact information in the chat in case anyone needs me for anything. And Matt, I'll let you wrap up.
All right. Thank you, Janis, so much for sharing your time, your expertise with us. Thank you to everybody for joining us today as well. We will have a recording of this posted to our YouTube channel within the next day or so. So you're free to go ahead and check that out, YouTube at Philly Realtors. And we'll send out an email probably sometime next week with links to that as well. So if you don't catch it on the YouTube channel yourself, we will be sure to push that out later on. Janice just raised her finger for something.
There's a question. I just saw a question. Is that the same for an agreement of sale under additional terms? Is what? Karen, if you're still here, if you could unmute. I just saw your question in the chat. You still here? Okay. I don't know the answer because I don't understand the question. Sorry. That the same under. Oh,
So
yes. You'll go to jail for the agreement of sale under additional terms too. It's the same for any contract. I know what you're talking about. That paragraph, additional terms, is not for us to write in. So here's what happens. If you have, let's say, one that I see often is if any contingency falls on a weekend or holiday, it goes to the next business day. If you wrote that yourself and somebody challenges you in court, not only will it may not hold up, but if it comes out who wrote that and that was you thought everything was fine. And guess what? Now you're not only in trouble for the contract falling apart, but you're also in trouble for writing a clause without being an attorney. So my advice to you is if there's a clause that you're going to need to use over and over again, have an attorney write that for your brokerage and it becomes your proprietary language. And the attorney allows you to then copy it and paste it in your documents over and over again. You pay once and you get it done the right way, and then you can use it over and over again. Otherwise, don't write in there at all. Even if it's the simplest thing and you're like, we're including the light fixture, be really, 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 really careful. All right, I'm done now.
All right. Thank you very much for the question and thanks for the answer. And with that, everybody have a great Thanksgiving. So glad to see so many of you here. Remember, we got the sessions going on next week, but until then, take care, enjoy the holiday and the rest of today. Take care. Bye-bye.
Thank you.